good faith exclusion clauses, and then tomorrow we will take a sort of a survey of the shading factors, duress, unconscionability, mistake, and frustration. We'll probably spend more time on unconscionability because that's someone who I imagine we'll want to discuss that a bit more. And then Wednesday, we move into tort, and I put up the tort files on what I think I'm going to do is I put up the notes for remedies for contract and tort. But what I think I'll do is I will skip that, so it wouldn't be examinable. But you have the notes there. And what I think I'll do is move up the last section, which is misrepresentation in contract and tort. So the overlap between contract and tort, move it up by a day so we have a bit longer for that section. Does that make sense?
Sorry, you said you're going to skip what?
Remedies.
Remedies? Okay.
That was one class. My supposition is that tort may take maybe a bit, may take a bit of time for people to understand a bit better. Contract, I think there's a bit more of an overlap, except for the topic today, good faith. So good faith in the common law, up until in Canada in 2014, has been something that the common law does not want to recognize. Now, I've given you sort of a working definition from a British case. And what I thought might be better is I'll just talk sort of a bit generally about good faith, and then we can move into a discussion of the topic, focusing around Bazin and the Callow decision from last year, the Ontario Court of Appeal. And then in the second part, or around the break, we can move into exclusion clauses. So good faith the concept of good faith in the common law can be divided into two portions, let's say. The negotiation in good faith and then performance in good faith. What has been maintained even now is that there is no good faith duty to negotiate. But as of 2014 in Canada, there has been an organizing principle to perform contracts in good faith. And as a subset of that organizing principle, there's an obligation to act honestly. That's what we get kind of from the Bazin decision. What I've tried to do so far with the cases, with what we've covered, is look at the content of the cases and putting it together in a way that I hope is manageable and understandable. And to facilitate that, I've talked about understanding what I call the philosophy behind the decision, and picking out certain cases that illustrate this philosophy. And good faith is sort of a transition point. Because philosophically, recognizing good faith in any form in the common law has not been welcome, except in discrete circumstances. For example, where there's a term in a contract that talks about good faith, that could be given effect. Or in employment cases, there's been an element of good faith in terms of termination. And we got that from the Wallace United Grain Growers decision in the Supreme Court. But generally, there's no overarching obligation of good faith in the common law. And the question I put to you is, why do you think that has been? Why has the common law been averse to recognizing good faith in any form other than discrete instances? Zita and then Constantine.
Because I think this emphasis on the freedom of the parties to determine the terms of the contract, and also common law tends to accept uncertainty of to accept more the uncertainty of the condition. So parties can decide whatever they want. They can have bad deals if they want, and the court is generally reluctant to get into the intentions of the parties.
I think because it has evolved that it's a commercial transactions, and we have this idea that the parties are supposed to pursue their own interests, and we're maybe the system is afraid that it may cause too many obligations and bring some uncertainty.
Yeah, uncertainty, both of you have mentioned uncertainty. I'll get back to that in a minute, but Constantine's point about self-interest, I think, is an important one to keep in mind. For whatever reason, the common law has maintained an adversarial position between the parties, whereas I don't know if you can tell me through your own jurisdiction, civil law is not necessarily as adversarial, I gather, as common law is. And Zita brought up the point about freedom to contract, and part of freedom to contract is if you're better than the other person, then you should be able to extract a good bargain for yourself, and who cares if the other person is ill-equipped. That's just the sort of adversarial nature of the way things operate. Enrico, you have your hand up.
I agree with Constance on what she was saying with respect to it's sort of the abstract. Good faith is sort of an abstract concept that isn't a law, and so it's difficult to pigeonhole. And I noticed by reading the cases, although they allude to good faith in a lot of situations, there's always a actual fundamental legal concept underlying the actual decision. So it's almost like they try to stray away from the good faith doctrine and then pigeonhole each case into a sound recognized.
And the term that both Zita and Constantina use of uncertainty, I think, comes into that. Because the question then would be, what is good faith? What constitutes, for example, negotiating in good faith or good faith performance? It becomes a bit nebulous. Because if we think about good faith negotiation, if you're looking out for your own self-interest, would that be antithetical or opposite to good faith? If you're in a negotiation which presumably at least has an element of the adversarial, good faith would seem to suggest you have to not only think about yourself, but the other side. So in the common law, they don't want that. But when we get to the performance aspect, Basman is saying there is a good faith duty to perform. What does that mean? A good faith obligation to perform the contract. Put another way, if, as we were saying, formation of contract is so important because courts will not let the other party out of the contract for any reason, how is that, why do we need good faith performance? Isn't that just another way of saying performance? Don't you have to perform the contract if you're obliged to perform the terms? Good faith would seem to be superfluous, but also maybe a bit of confusing term to add into that. So what's the difference between normal performance and good faith performance?
I'm just kind of predicating on the case that we were supposed to read. They talked about like
The Bazin case.
The Bazin case, I believe. Or was it the CM Powell case?
Yes. Which one were you talking about?
The CM.
Okay.
And from their narrative, they talk about the self-interest preservation and how it's like equates to economical efficiency. But then they also talk about the different thresholds of good faith. And I guess from their rationale, good faith kind of sounds more like about being a little bit more transparent. So that would parties know the terms and conditions are within that confines of that contract.
Okay.
And I guess that's pretty much the standard that they're looking at. The other parties are aware, and you guys have I guess we need to understand what's expected.
Yeah. David, you had your hand.
I was just thinking of good faith performance in the form of like between a buyer and a seller, where the seller or supplier is to supply a particular maybe raw material, and it's expected that the raw material should be of high quality, and probably after the first supply that was of good quality, the subsequent ones wasn't that up to standard.
Right.
So that's the way I look at good faith, that if an agreement was reached for the supply of a particular product or raw material, that basically what you expect is something of good quality and not less. So
Okay.
yeah, that's the way I look
Where
at
it
it.
wasn't defined, so it wouldn't be a breach of a term of the contract, is what you're saying.
Yes.
Okay. Edward, sorry.
Yeah,
I'll come back to you.
so from the Basin case, I think, like as I understand it, that they use the contract to pressure Basin actually to merge with the other contractor.
It wasn't really a merger.
Hmm?
It wasn't a merger. And so Bazin factually, what it's about is Can-Am put Hernu in charge of Bazin.
Yeah.
So Bazin and Hernu were competitors in this region. And for whatever reason, Can-Am said Hernu, whose business wasn't doing as well as Bazin's, you're going to supervise Bazin. And what happened was basically Hernu pillaged Bazin's business. So Bazin ended up basically with no business. So it wasn't, I want to separate that because merger makes it kind of sound a bit friendly. There was nothing friendly in this setup.
But it's kind of like they use the contract actually to like establish or achieve some extra gain not related to the contract itself. Can we say that is like performing without good faith?
You get an added benefit outside of the contract. I guess in good faith though would have to have some element of detriment to the other party. Because if, I don't know, I can only think of silly examples right now, but if in performing the contract, your contractual obligation, you end up getting some extra added benefit out of it. That wouldn't necessarily be good faith. Breach of good faith. If you did it to the detriment of the other party, maybe then it'd be questionable good faith. Before I forget, I'll come back to you.
I was just going to say, I think that good faith is to do with intention. So if I perform the contract, honoring the terms of the contract in good faith, so I don't knowingly get an added benefit, even if I know that the other person is not going to, how can I put this? So the other party, if I can gain benefit over the other party without them knowing about it, that would be a breach of good faith. Because I intentionally know that that I'm not honoring the contract, or I'm going beyond.
The one question I have though is, does intention make this an insurmountable threshold? If you have to prove that the other party intended to screw you over, how do you prove that? I would say what Basman is telling us is, on an objective assessment, was this good faith performance? So the intention part would be objectively assessed, let's say, so a reasonable person in this circumstance. Otherwise, I think we have too high of a threshold to meet. And we'll see this with tort. If you try to prove that somebody wanted to deceive you, that's an intentional tort. You have to prove they intended to deceive you. But if you sue in negligence, which says, well, they were just indifferent or reckless, you don't have to prove intention, that higher threshold.
So would the standard be would have known or should have known?
Something along those lines, like a reasonable person in this circumstance. So in Basel, I think the Supreme Court is saying, well, objectively, Can-Am could not have been operating in good faith because they put Hernieu in this position, this supervisory position, to Basel for whatever reason, while they were still saying to Basel, we will renew, or we have every intention of continuing our relationship, our contractual relationship. When in fact, it seemed as though they didn't, because they were talking about doing everything but that. So within these very discrete facts, I would say Basel is a precedent, but only in this circumstance. What I mean by that is, put yourself in the position of representing Basel. What contract law principle has Can-Am or Hernieu violated? Yeah, but that didn't exist until 2014, right? So, and I've mentioned this sort of framework before for exams. If you're asking the court to recognize a new rule, and that's your only argument, you have to be prepared that that's not likely going to be successful. You usually want to package it with something more substantive. So arguing good faith alone, especially at the time of Basel, is a risky case, a risky argument. But that's why I asked, if you represent Basel, what legal arguments and contract law do you have available?
Misrepresentation.
What was misrepresented though?
Well, Can-Am asserted to President that Hernieu was not going to audit his files, he would not have like inside information, so that to me is misrepresentation.
Not in the contract law sense though. Misrepresentation is a vitiating factor at the time of formation. So if I tell you, buy my contract law textbook and you'll get an A, and you don't, you've entered into this contract of buy my book for this, on the basis of this false, clearly made statement. With that scenario, they haven't, Bazin and Can-Am never came to a new arrangement.
So the initial contract, there was no,
The initial contract they had, but what we're talking about is a renewal. So let's say it was a 5-year term. It's in the final year, and Bazin wants to renew, and Can-Am is sort of dragging things along. That's not necessarily misrepresentation, especially when they haven't concluded a contract in the end. It's not nice, but we don't have a remedy for being not nice. Yeah.
I know these are also not easy to prove or establish, but what about the breach of an implied term that you would not take any steps to decimate the business or allow a competitor to supervise the business, etc., etc.?
Yeah, so if you go back up in your notes, there's a Supreme Court of Canada decision from 1978 called Dynamic Transport. It's under the heading, it's the second case under the heading Best Efforts and Duty to Cooperate. And I gave you this rule from the case. The court will readily imply a promise on the part of each party to do all that is necessary to secure performance of the contract. Which I think is kind of along the lines of what you're saying. It's not saying implied term, but it's saying within a contract, each party has to do all that they can to perform within reason. I don't think this case was referred to in Bazin. And I don't know how far this takes us, especially if we have to keep in mind in Bazin, we can't have an argument that basically locks in Can-Am to the next agreement. The parties are free to, the clause says they can renew. It doesn't say they must renew. And so implied term or using dynamic, are we in effect saying you must renew the contract, or are we getting that?
Look, I mean, I wouldn't go that far. I would simply say that to the extent that you are inserting a competitor into my business through supervision, that is...
They weren't seeing them as a competitor, right? Can-Am.
Yes, Can-Am. I'm talking about Can-Am, yes.
Yeah, like they didn't see her new...
Sorry, inserting her new
Yeah.
in a supervisory capacity.
Yeah, they thought that was fine.
And look, again, I don't know what the contract said, but I'm not sure to what extent, you know, when they initially contracted to enter into the agreement, whether it was contemplated that some third party may have the right to supervise Basin's business. So, but you know, it's really nitpicking around the edges for technical.
Well, this is part of what I'm getting at, that I don't think Basin had another argument. But I would be very worried going to the Supreme Court and asking the court, by the way, could my client win and could you make new law? So what I'm pointing out here is, understanding civil law jurisdictions, depending on which ones we're referring to, good faith is a stronger concept. In common law, even now, I would say if your argument is good faith, I would package it with something else. So I've talked to you about a statement of claim. And some of you who work in law already may be familiar with this. A statement of claim is basically your lawsuit that you file, and it will say, Mr. X sucks because he did this. And then there'll be this other paragraph that will say, in the alternative. And what that means is, well, if my first argument isn't successful, then I'm also alleging this. And we do that at the statement of claim stage because we don't know everything. We don't have all the facts before us. Oftentimes that comes out through the litigation process of discovery and so on. So what I'm saying here is, I would want to have something like, this is breach of a condition, etc. In the alternative, you're alleging a breach of the good faith performance. Because the subsequent cases to Bazin really have not picked up on this good faith argument. We don't have a very strong concept of good faith performance, even now, about 5 years after Bazin. And as I said, I guess it'll be next year, the Supreme Court of Canada gave leave to 2 decisions, one of which I asked you to read, the shorter one. Maybe they will pick up the point then, but until that moment, it doesn't seem like there's a very strong concept of good faith performance being developed in the courts. So strategically what I'm saying is, and for exam purposes, if you think good faith is an argument, I would look for something else as well. Good faith, put very bluntly, good faith shouldn't be your only argument. It was in Bazin, but I suggest that the facts of Bazin were just so egregious, so bad. Bazin, I think we can all agree, was treated very poorly by almost everyone in humanity he ever came in contact with, based on this case. And I think it'd be a surprise if the Supreme Court decided otherwise. I don't see how they could have decided otherwise based on these facts. Bazin just misled in a non-legal sense throughout this whole process that it would be egregious for the Supreme Court not to give him a remedy.
I'm getting the sense that perhaps good faith as a principle is not a standalone principle in contract law, whether it's express or implied. Is this what you're getting at?
No, what I'm getting at is in terms of strategy in litigation, if you are in Bazin's position, you're representing Bazin, come up with another argument.
Yeah.
In addition to good faith.
But to still answer the question, is it a standalone principle in contract
It's
law?
supposed to be. Bazin says it is. Right?
Okay.
That there's this duty of good faith performance, and as a subset of that organizing principle, there's a duty to act honestly. Which I think the facts of Bazin uniquely illustrate, a breach of both. The question is, how far does this go? So Zita's point, when I asked why does the common law view good faith in such a negative way, part of what she said was, well, there's supposed to be freedom to contract. So does that bar someone from acting honestly? No, that's not what I'm saying. But there's scope for performance. And I think it might be best to delve into the Callow case to look at this, because the Callow case, I was surprised that the Ontario Court of Appeal found there was no good faith obligation here. Yeah.
As a real life or exam strategy, would you recommend using a more traditional,
That's what I'm saying.
but first the more traditional
Yeah.
concept and then good
Yeah,
faith
I
as
wouldn't-
alternative, or does it not matter?
So usually the hierarchy is your best argument is first. So I wouldn't put good faith first. I would put it third out of two.
That I guess goes with the UK, where good faith is still the default rule rather than the,
Good faith isn't the default rule
well,
in the UK. They absolutely abhor it.
So what
Sorry?
would be your argument?
no, there are cases where it's suggested it's a default rule. You have Burgess, the last, well, I don't remember the names, but having looked at them, and it was stated that it's not a rule in itself in the first instance, but as a default rule.
Good faith.
And what they mean by that, and coming back to what you're saying, it's part of the subset of some, there's a catch-all at the end, sort of.
Right, well, that's why I gave you the Yan Sang decision.
That's right. Yeah.
In Yan Sang, it's a trial level decision from the UK, where the trial level court says, look, this whole thing about the English abhorrence of good faith really is kind of silly, we say. Because really at its core, all we're talking about with good faith is acting honestly. And don't we all want that if you're in civil or common law? Nobody's followed Yan Sang. Yan Sang is not precedent.
But it's not overruled.
It's not a rule.
Oh,
It's not, so, I'll be happy to discuss it afterwards with you, but there is no obligation of good faith in the UK contract law outside of a specific clause that states you can do this in good faith, which I think comes from a Court of Appeal decision called Mid-Essex. Other than that, there's been no recognition whatsoever in English contract law that there is an obligation of good faith, negotiation or performance.
the obligation only stands where there's express terms in the contract,
Right, that's
but
what
it's not implied. I think
That's what
that's the
I'm saying.
distinction in the UK.
That's what I was saying. So if there's an express term, they will give effect to that. But there is no, in Cromwell's terms, in Baza, no organizing principle of good faith in Canadian or in English contract law in terms of performance. Yeah, I know.
The thing is, in practice, in my understanding, if you look at some commercial B contracts like mining contract or investment contract, these are usually like the provision of good faith. So
Is there?
yeah, then for example, you know the Anglo,
Contracts?
yeah, Anglo-Australian the mining giant, the Rio Tinto. Yeah, I had a chance to look at some contracts, the number of contracts. There's usually good faith I saw.
Because
Then I thought like, oh,
I think our prime minister would argue because he was embroiled in this whole problem with SNC-Lavalin.
then I thought like good faith is maybe the part of the principle of deriving from the common law at that time.
No, there'd be an express term, but honestly, I'd be surprised if there was much binding big multinational corporations to anything good faith. I'd want to see the wording before I accepted that companies would bind themselves to good faith.
I was just going to remark about this sort of lack of appetite.
Yeah.
Given, for example, although I accept they're separate species of contract, but as I'm sure most people know, in insurance law and insurance contracts, we have this concept of utmost good faith.
Yeah.
And it really derives from the notion that the insured is really in a unique position vis-a-vis the insurer a lot of the times in relation to what they know about the insured risk. So I would have thought that that kind of principle, certainly in the negotiation stage, ought to really, and it's not that controversial to apply a similar sort of approach to information that is within the kind of knowledge of the particular party, as it were.
Well, insurance contracts operate in a unique way,
Yes.
as you point out. The flip side to it, and I want to get to Callow, but so I'll leave the question and we'll come back to it, is part of the opposition to recognizing good faith is, well, why do we need this? Because we have these other tools. For example, we'll look at duress or unconscionability, misrepresentation.
Stop it. No.
So each of these say, well, one party can't operate in a dishonest manner. You can't lie to someone and get them to enter into a contract and be bound by that lie. So why would we need good faith? Because we already have these tools in the common law that give effect to the same point. And as I said, I'll come back to that. So if we look at Callow, what was happening in Callow? I asked you to read the email last week.
Mr. Kelly provided service to several condominiums, and there were two contracts, one for the services over the summer period and one for the winter period.
Right.
The respondents, they knew they wanted to terminate the contracts.
Right.
They knew it in spring, but they did not tell that to Mr. Callow until September.
Why?
Because they didn't want him to stop providing the services over the summer.
And I think they were also concerned about how he would perform.
Exactly.
Yeah.
They wanted, they made him think they would continue with the contract.
Yeah.
And he would perform some services like extra. He made some
Freebie work.
Some
They call it.
landscaping work. So when they communicated this termination to him in September, he said they were acting in bad faith.
Yeah.
And the Court of Appeals said that no, there was no element of bad faith here.
Now, and some of the details are important here. Under the contract, when did the condo corporation have to tell Callow?
10 days.
10 days before. So the condominium corporation's argument is, we had no obligation to tell him until 10 days before what? The termination. That what our decision was. So the Court of Appeal, I think, is saying the trial judge erred because he or she, I forget who it was, expanded that. Basically said, expanded the 10-day period by reading in a good faith obligation here.
And the Court of Appeals said that Mr. Callow basically agreed to the 10-day notice for termination.
Yeah.
So that's what he got.
Yeah, and just reading paragraphs 15 and 16, paragraph 15 halfway through, not only did the appellants, and that was the condominium corporation, fail to inform the respondent, Callow, of their decision to terminate, but they actively deceived Callow as to their intentions and accepted the freebie work he performed in the knowledge that this extra work was performed with the intention and hope of persuading them to award the respondent additional contracts once the present contracts expired. In our view, these findings may well suggest a failure to act honorably, but they do not rise to the high level required to establish a breach of the duty of honest performance. So this is the crux of the point, Constantine.
So honorably is something different from honest. That's why.
Yeah, so in terms of the language, the semantics of language, they're saying it's sort of the difference between being polite and being obliged. So it would be impolite for me to kick you, but I'm not obliged not to. If that makes sense. I'm just thinking off the top of my head with example in retail.
This
And then
case, I think wins.
Sorry?
If this case is successful, I think we're in serious trouble. Because what we're basically saying is that, people can't be strategic in business negotiations. Think about it. Imagine you're an employer, you have somebody that you want to replace. And you have a contract, one contract that says there's 2 years termination. And you already know that you're going to replace this individual in advance. If you let that person know that they're eventually going to be replaced, you know that the performance is going to go down. It's just a natural.
But it isn't that simple here, right? Like, Callow did more, what we call the freebie work.
On his own.
Yeah,
The expectation.
But they were happy to take it.
Sure.
Yeah, like we can say, if you give me $1 million, that's really generous of you, but I don't owe you anything.
If I have 2 individuals that are competing for positions, say, at my firm, and one tries to
Sure.
go up and above, says, look, I'll take work home, and I said, look, you don't have to, if you want it. In the expectation that I'm going to choose that person in addition to the other person. At the end of the day, if I don't, because I recognize something else in the individual, despite the hard work of candidate A,
Sure.
does that mean that I've acted in bad faith? I mean, this is a dangerous decision. The Supreme Court of Canada, this is going to open up a serious door for
I don't know.
area law.
I don't know if it necessarily would.
No.
Because again, with the facts of Bazin, I think we have particular facts here.
Nobody's going to be successful.
Maybe not, but I think that there's scope here for the Supreme Court to say, well, hold on. Like, you made your decision, you didn't tell him because you were concerned about how he would perform the work. And you accepted additional work, knowing you weren't going, that he was doing only in the aspiration of a renewal. Like, at what point is this dishonest?
We could go the other way.
Sure,
If you have
but-
a disgruntled point, I'm using this example. because we're
Yeah,
gonna have something-
it's not that, like, because this is a bit different. In employment, we have Wallace and Keyes to talk about good faith in the employment setting.
Right.
But here, when you have somebody competing for renewal of the contract, at what point does this conduct become dishonest, is the question. Like, I don't know,
Yeah.
but I'm putting it out there. Anna and then Zita.
So, on this concept is sort of civility to professional responsibility. Because it looks like it is exists to cover all areas which are not covered by the misrepresentation, other instruments, right? So, like in Bazin case, they can't use anything else, so they choose this option. It's different.
Yeah, but so if Bazin is sort of, were backed into good faith, let's say, but I hope it's accurate in how I characterize what you're saying. Why wasn't it applied here would be my question, in Calum. And Zita, you had your hand up, Ebra and
I
Dave.
have 2 notes. One is that the fact that he felt he had to do extra work to persuade the continuation of the contract or the
Yeah.
renewal, it shows that he was not sure it's going to be renewed, or and he couldn't be sure, or he
Sure.
was not such a good performer before.
I don't know, but I don't know we can infer too much from this. Like, I would say he wasn't sure,
He wasn't sure.
but
Okay.
It was an offer.
Yes, and I have another note. The
Yeah.
other note about the interpretation that we were talking. When something is explicitly, clearly said in the contract, right? The interpretation law is different. Or it's very, the court doesn't like to get into it when something is very clearly stated. Here it's very clearly stated that he has to say 10 days before, and not earlier.
Yeah, but I would suggest if that's how the Supreme Court will deal with this case, that's a very narrow construction of the issue. I don't think the issue is, are we giving effect to this 10-day clause? I think the issue is more, how do we characterize the conduct of the condominium corporation in accepting the extra work and arguably misleading Caleb? That's more what I think the issue is, and not specifically the 10-day, what the hell is it?
What they should have done, they should have paid for it? Offer payment for the extra?
No, but they could have said, no, we appreciate you doing the extra work, but we don't want you to do that. Like you don't have to accept all the free work that somebody offers. You know, and arguably this gets into another area of law, but at what point does somebody become unjustly enriched?
I mean, that's I would like to say that unjustly enriched. Do you think it's the bad faith, the act of condominium corporation?
I don't know if I would call it bad faith. I think that it's certainly dishonorable. The court reveals that. I think the problem is factually, they let the guy to think that he was still in the running when he wasn't.
Yeah, they let him on.
And secondly, they accepted the free work. I think those are problematic points.
Wow.
Ebra and then Deon, and then I'll come back to you.
Yeah, I think, like you said, like in the Callo case, what the appeal court said that it's maybe like dishonorable to act that way. But I think it's different from passing, that they were just like not disclosing to the other party what their intention. So they were like more passive, if we can say. So they didn't do any acts to give the other party the idea that they're gonna like renew.
Yeah.
Yeah, maybe if they said to him like, if you do some extra free work for us, that's gonna be like acting in a bad faith. But because they just like they didn't disclose, and they don't have like the duty to hold a disclosure.
Yeah. Okay. Dan?
Oh, I was just wondering, actually, I have one question. Like, everyone is all of a sudden getting kind of worked up with freebies and extra work, but you're talking about unsolicited services. And, you know, when you come back to the basics, offer and acceptance, who cares? Like, you know, I can have Rogers giving me 250 channels for 6 months.
I don't think
and
Rogers
sending me a bill, and
has ever been used in the same
and I'm telling,
sentence as good faith.
I'm telling them, thank you very much. I watch them all the time, but I'm paying them nothing because
I just get blank screens with Rogers. This channel isn't in service.
So there's no consideration, no offer, and no acceptance. Whatever was given, it was unsolicited. Whether there is unjust enrichment or not, I don't know. You know, our friend obviously was working hard to get a business.
Yeah.
So we all treat our major, you know, clients with freebies, free lunches, free dinners, games. Everyone does that.
Screw that.
So all of a sudden,
Give me a free one.
yeah, no. But making a principle, as the trial judge did, talking about minimum standards of honesty, which was not explained, and I wonder what's that? What's the minimum standard of honesty?
Yeah.
You know. One more thing that I wanted to mention, if that makes any kind of bearing, I'm having issues kind of putting things in some kind of a perspective.
Okay.
So we have a good faith, right?
Right.
And then we have a bad faith. So what's in the middle? Faith?
That's a normal procedure.
I understand, good faith is organizing principle, like, we are supposed to hold hands and be shared, kind of, we're polite, let's make a theater out of that. Bad faith, I maliciously want to use my contractual right to deprive you from the root of commercial connection. I got it. So what's in the middle? What's in the middle? And nobody is mentioning the middle. It's like basic performance, no adjectives, nothing.
Yeah, well, to deal with that question, your last question a bit more, it's been articulated a bit already. What we're looking at with this idea of good faith performance is where something arguably has been done wrong, for lack of a better term, but it doesn't violate the orthodox contract rule. So Basel, as we said, Can-Am didn't do anything that violated contract law, but they still lost. Because the Supreme Court said there's an organizing principle of good faith, and as part of that, there's a duty to act honestly.
One more question on that point.
Yeah.
You said nobody was arguing anything about the contract in Bazin. But why Bazin wasn't really claiming, intentional interference in contractual relations?
Because he had to prove intention.
Well, that was easier on the facts to prove the intention because they wanted to squeeze him out.
No, as a general proposition, I would say you want to stay away from anything that has the word intention.
Okay.
Because that standard, you have to prove that somebody intended to. Put another way, look what's happening in the US with Trump. Like all this stuff about the Russians were, no offense to the Russians wanted to put Trump in power. Trump campaign was happy to receive him, but there was no collusion. Well, at what point is there collusion? Just because you have two parties that didn't meet in the middle, that is where I'm saying intention comes. When you have to prove that connection, that's a high threshold. And we see how high it is in what's happening in the US right now. So that's why you go for the threshold that isn't intentional.
I was thinking about alternative allegations,
Yeah.
as you said.
Yeah.
You would throw at the wall whatever can stick to it is in your plea.
Yeah.
So contractual arguments, tort arguments,
Yeah.
anything and everything you argue. And you said nothing else was argued other than good faith.
Yep.
So I was just mentioning.
No, I understand. But I want to convey on your point about, I just remember as the faith point, what's in between good and bad faith. So if we talk about faith, what we're looking at is not was there offer acceptance or this or that. It's there is something off, for lack of a better way of putting it. Did it violate these rules? And generally speaking, right now our language for, catch-all language for things that aren't orthodox is good faith. Did it breach good faith? And this circles back to where we started. Part of the problem with good faith is we don't have a firm idea or definition of what it means. Just as we can't define bad faith. Good faith, I think we can find the definition will differ violently from person to person, especially in a contractual scenario. So inevitably, we're going to have decisions made or what seem to be arbitrary decisions made. The question I have is, if we have Bazin, why did Callow fall below that? That's what I'm not clear on. I'm not necessarily saying the Ontario Court of Appeal was wrong. I'm surprised by the decision. But what I'm saying is, how was this not dishonest?
Well, if I may say just one more word, I apologize for this one. Well, I think that Basil, first of all, we should, as you mentioned, we should look at the customs. You're talking about apples and oranges. They're like fruits, but they're kind of different species. Because in Basin, it was a contract for getting the educational funds or whatever. It was a long-term contract, 3 years, plus automatic renewal.
It wasn't automatic.
It was automatic renewal on notice. If you don't, you have to give 6 months notice.
Yeah.
So those kind of contracts in commercial sense are giving you a flair that someone is getting into a long-term, ongoing relationship.
Yeah.
Here, you have a maintenance contract by a guy who cuts the grass, shovels the driveway, puts some salt, that's it. Those guys, they come and go. Like commercial customs are that, you know, there's so many contractors out there, go and find yourself the one that you like.
Yeah.
That, you know, brushes teeth every day, so doesn't have a bad breath or whatever. Shaves every day, you know, doesn't stink. It's up to you. So I'm looking at.
I think we're getting at the floor of what Dayon
No,
expects
I'm
from a
trying to.
condominium
I
manager.
mean, those are different contracts, different circumstances where you may think that in one setting with a long-term goal of, you know, prolonged litigation, something more should be there in a sense of some relation. Over here, nothing is over. Be my guest.
Yeah.
I'm thinking that.
Spartak and then Don.
I was trying to recollect a little bit from the civil law doctrine, and the way how they treat the good faith element is that the innocent party has to be mistaken. So there is an element, because if the party was claiming good faith, they would have to prove. And of course, they cannot prove it based on the intention of the other party, because that will create problems. But they would have to prove that while performing, they were mistaken, like for the actions that they did.
Okay.
Like they weren't obligated by the contract, or they didn't have any obligation, but they still kept doing it in good faith. Now, in Callum's case, there is no element in there that Callum was mistaken for the conduct that he did. Like he had a clear intention, I'm doing this in order to secure services going on.
Yeah.
So I don't, I think that the Court of Appeal was right with this decision.
Okay.
So.
We already touched upon it, but it kind of just reminded me of those Thomas City stopper cases, and even in England, kind of like some of those proprietary stopper cases like Turner was major. And I think when you take a look at like alternative arguments, he could have potentially argued maybe it's Thomas City stopper, but I think what kind of like stopped before that threshold was just because they didn't make like an unequivocal and unambiguous statement, which he could have relied upon that acted towards his detriment.
Yeah, it wouldn't have been reasonable reliance.
And I think that's just kind of where it is.
Well, so Dayon's categorization of property managers led me to think of this. Is good faith in these cases a proxy for something else? In Bazin, in Callow, we're not dealing with big corporations. These are what we might call small businesses. I'm not 100% sure, but I think Bazin operated his own business. I don't know if he even had employees. If he did, he had a few. Is good faith becoming the argument where we see what's called an imbalance of bargaining power? And I want to qualify that by saying, I'm not saying that in Callow, condominium corporations are like multinational companies. What I'm saying is, in each of these cases, we have this individual who arguably was wrong or feels aggrieved. And are we using good faith as a way of expressing that aggrievement?
gonna say, I think the problem with Basin was, like you mentioned previously, they didn't really establish a barometer of what fits in with less scope, of what constitutes bad faith.
Yeah.
And because to me, when I'm kind of reading over the case back to it, I think that a huge factor was that conflict of interest part. That they brought in Cannon as like an auditor kind of, and that's their direct competitor, right?
Yeah.
And pretty much based on that, they're pretty much telling the company that they were promoting that, you know, you should drop these guys for that reason. And then it kind of makes me beg the question of like, where do we stop? Like, what entails within the definition of good faith?
Okay. So I would keep watch for this decision and the one coming out of BC as well. The BC facts are fairly different, I think, from this one. But hopefully there will be some greater clarity to the concept. Because I think Basin really has left things quite ambiguous. And I understand how that is in a common law system on a case-by-case basis. But it seems to be, maybe it's not workable, this idea of an organizing principle.
Well, Greater Vancouver decision is actually pretty much in accordance with the same color. Deciding that there was no real, nothing bad was happening. And what I like so much is that they actually pounded over the arbitrator about considering things outside of the contract.
Yeah.
It's just the present contract that we are focusing on, not the future contract.
Yeah.
Not the missed opportunity. It's like what you did and what was required to be done, and was it done fair and transparent?
Well,
if not, then any future things that, could have, should have, maybe, that's irrelevant thing. I mean, you're talking about bad faith with regards, or good faith with regards to a particular contract.
Yeah.
But with regards to an extension. Extension is an issue.
That's why I'm saying, I wonder if good faith is a proxy for something else, whether that's imbalance or we just feel there's something not right here. And also that I think Basin was insufficient in giving guidance as to what's happening. Maybe left it too wide open as to what may constitute good faith.
The U.S. Code of Uniform Code, they seem to have a clear definition of good faith as honesty in fact in the performance of a contract. And if you read along some of their cases, the concept of fairness seems to pop up quite a lot.
Yeah.
And they're clear about it. It's really acting honestly, but within the terms of the contract. So why is that so difficult for us to absorb in the Anglo?
Well, I wonder how clear it is in the US even though, because what's fair? It seems more philosophical than legal when you start arguing about it. I think as a general concept, this idea of good faith or fairness is difficult to articulate within, I would say, the common law system. Because I think you have these tensions like freedom to contract. Arguably, good faith is opposite to freedom to contract. Because it puts a parameter on how you do things. I'm not saying doing things dishonestly, but the argument would go, well, you can't do something that will leave somebody else worse off, if that's your definition of good faith or fairness. Well, that's not the way things operate. That's not how the negotiation would operate in common law. That's not even something that should be in common law thinking given any sort of weight. So when we look at what constitutes fairness or good faith, I think we're still sort of stuck on what's the definition. And that continues to be the problem. And so part of the criticism I'd have for Cromwell's decision in Bazin is for something so monumental the common law has rejected for so long, he really didn't do enough to address what it was that he was doing. Calling it an organizing principle. What's an organizing principle? We can say, well, it's not a rule. It's a way of thinking, a way of operating. I don't know what that is. And then, as a subset, it's a duty to act honestly. You know, he didn't distinguish it from the current tools that are there. As I said, with vitiating factors like misrepresentation, duress. What is it that good faith was adding here? And that's why I say I think it was more of a response to the facts of Bazin than anything else. But it fell short of doing the job of what we expect the Supreme Court decision to do, and that is provide guidance on key areas. And this is a monumental change, recognizing good faith performance. That was left, in my opinion, too vague.
Just a follow-up question.
Yeah.
I know in the US, again, referring to that, the good faith concept is not applicable at the negotiation stage, but at the performance.
Yeah.
Do we have that distinction in the Anglo-Canadian law?
Yeah, that's what I said at the start, that there is no good faith negotiation obligation. In Canada, there now is for performance, but in the UK, there's nothing except in express terms, which is odd because, well, until end of October, they're part of the EU, and the EU has a very strong or stronger sense of good faith, but they've always pushed back on it. Any other final points? Yeah.
Just have a bit of a difficulty trying to understand and keep something with good faith negotiation, good faith in economies.
Yeah.
You think at some point the lines would blur. How do you make that decision? If I negotiate with you and I promise you will, and in all intents and purposes, I mean, none of the promises that I'm articulating to you, I actually need to perform.
But isn't that misrepresentation? I think the demarcation point is formation. You can, so I think that the concern is, as I said before, if you have an obligation of good faith negotiation, you have to think about the other side. And that is antithetical to the adversarial nature of negotiations. Whereas once you have concluded an agreement, the thinking goes from Bazin, then you should do what is reasonable within your power to affect performance, minus these other things like force majeure and so on. So I'm just going to start a bit of the exemption exclusion clauses.
So, sorry, just for clarity.
Yeah.
So in Canada, basically, what you're saying is, for good faith, the only requirement here in Canada is just good faith in performance and not in negotiation.
That's what I said.
All right, thank you.
So exclusion clauses is where we sort of end with our assessment of what's in the contract. And I would say that this also extends our discussion of interpretation. Because in effect, we are interpreting the contract and in particular, the exclusion or limitation clause. Now, if you think about it, this kind of a clause brings up the question, why have a contract at all? And to give you a very simple example, if you have clients come in your contract, you say, if I mess up, it's not my fault. That would be an exclusion clause. What's the purpose of the contract? Because basically you're saying, it's not my fault if I do anything wrong. So there's an inherent skepticism in common law courts regarding especially exclusion or exemption clauses. That is, those clauses that say, if anything goes wrong, it's not my fault at all. As opposed to a limitation clause, which says, if something goes wrong, my liability is limited to X amount. And to give you a practical example of that, you'll notice a lot of the big law firms in Canada are called LLP. Is that right? LLP. Get mixed up with that. Limited liability partners. Which means each partner's liability is limited to, I think it's about $1 million.
Yeah, it's a basic.
So that is treated differently from an exemption and exclusion clause. We're going to focus on exemption and exclusion because these clauses are saying, regardless of what happens, it's not our fault. And I'll draw your attention to Chief Justice Laskin, as he then was in the B.G. Linson case, just in the italicized note at the start of exemption clauses. He writes, there must be a residue of obligation that is not canceled out by concurrent exemption. Otherwise, it is illusory to speak of a contract. This is giving you sort of a case to cite for the proposition that I was saying before. If you have an exclusion clause, what's the point of the contract? So there's a process we go through in order to assess exclusion exemption clauses. But that process, I think you have to keep in mind, courts are going to scrutinize these clauses probably a bit more than they do other clauses, for the reason that I've articulated citing Chief Justice Laskin. So I think that it'd be best to pick up that process when we come back at, I can't tell Connor, 7:50. That's 20 minutes. And Starbucks is open. It's open till 9. For anything that goes wrong. So there's a process in terms of how courts evaluate these clauses. The first step is incorporation. And the question is, has the clause, the exemption clause, been incorporated into the contract? And a good example of this is the Thornton and Shoe Lane parking case. I think you have an excerpt in your textbook. Thornton versus Shoe Lane parking. This case, again, you have an excerpt in the textbook, but I'll briefly go through the facts. This case, I think, is useful to illustrate the point of incorporation because it physically represents incorporation. So Thornton is entering into a parking lot, and he gets a ticket from an automated machine. He drives in, parks the car, and on a wall inside the parking lot, it says that shoe lane parking excludes liability for any theft or damage to property. And it just so happens somebody thefts and damages his property. And shoe lane says, well, we're not liable for that. And the Court of Appeal says that that clause was not incorporated into the contract. Why do you think it wasn't incorporated into the contract, based upon the facts that I gave you? Right, so when would it have been valid, the exclusion clause? Maybe at the back of the ticket or some sort of notification before entering the parking lot.
Even the ticket is already in another case, it says it's not really valid.
Yeah, that's what I was saying, at some point before entering into the parking lot. So the idea is that you have, if you think of the parking lot as a physical representation of the contract, once Thornton entered into the contract, an exclusion clause could not be part of that contract because it had already been formed when he took the ticket and then entered in. So the clause was brought in after formation and not at the time of formation. That's why I said in order for it to be valid, Thornton would have had to have been notified of that exclusion clause before entering into the parking lot. So when we're looking at assessing exclusion clauses, the first step is to look at, was the clause part of the contract, in another way of putting it, or was it incorporated into the contract? So did it form part of the contract? That's stage one. Stage two, we can subdivide into two parts, both dealing with interpretation. The first stage is, does the exclusion clause deal with the subject matter before us? And then the second one, we can bring in some of the cases regarding interpretation of exclusion clauses. Now that first stage, does the exclusion clause pertain to the subject matter? The reason that I say that is, if we think about an exclusion clause that says, we exclude liability for damage to property, but someone is physically injured, then the exclusion clause does not apply because the harm in that case is a physical injury. In order for the exclusion clause to exclude liability for things, the best way to do it is to have it enunciate what it's excluding. You'll see sometimes, like the parking lot case, exclusion clauses will be worded very generally so as to try to capture any sort of permutation of the event, like we exclude all liability. Courts can scrutinize that in different ways, but the key point here for interpretation is we're looking at, does the exclusion clause deal with the subject matter before us? So again, if it excludes damage to property, but it's a physical injury instance, then the exclusion clause doesn't apply. The second aspect of interpretation, we look at the cases. And the cases give us some interesting arguments, let's say, that could be applied. For example, Smith versus Eric Bush. And I'll give you the facts very simply.
Yeah, it's valuers of the houses.
Yeah, so Eric Bush performs a survey of a property. And he values the property at a certain amount. And he says in the evaluation, if I'm wrong, you can't sue me anyway. Now, he performed the survey for, I'll translate it into North American terms, for the borough, or the council, like North York or Scarborough. He didn't perform it for Smith. Smith comes, buys the property, and part of what brings her to buy the property is the survey. The survey turns out to be incorrect. She sues Eric Bush, and the Court of Appeal says she wins. Now, why was that? Well, a key part of the decision was Smith was what we would call a low-income earner. It was Smith and her daughter. And the Court of Appeal said, well, people in this kind of position will not be able to afford to purchase their own independent survey. Because of that, they will rely on what Eric Bush says. Because of that scenario that Eric Bush knew of, he had to take proper care. Since he didn't, he's liable in this case. So the idea here is who is the recipient of the exclusion clause. What Eric Bush tells us is, if it's sort of what we might loosely call a vulnerable person, like an individual that doesn't have a lot of money, they will be treated differently from, let's say, a person that owns multiple properties. If Smith was a wealthy person who owned multiple properties, the court probably would have said, you could have afforded another survey, you should have gone and done that, you have no case against Eric Bush.
Excuse me.
Yeah.
So, just thinking back to the cases, how would we measure up the good faith in this instance where the courts are saying, hey, if you are able to afford this, then the surveyor may not
How
or
does good
may
faith
act
come
in-
in, though, here?
Because you're saying the courts will treat
Well, like the case says.
the cases, sorry, the courts will treat the person that's in a better situation as more responsible for their position. Like, you're able to go and get a surveyor's report, then go and get it.
Yeah.
Therefore, the surveyor, Eric Bush, is able to, in that instance, still act in bad faith by saying, hey, I'm not.
Yeah, but that wouldn't necessarily be a bad faith scenario. It's not like Eric Bush said, I don't feel like doing the survey. I'm going to write whatever number. He did the survey, he did it improperly.
Yeah.
It wasn't bad faith. He just messed up.
But isn't bad faith and good faith like honesty, doing the contract in honesty?
Yeah, but think about yourself in working in a law firm. You give advice. Turns out it's the wrong advice. Are you acting in bad faith?
If I'm not aware that it's bad advice, then, it can't be in bad faith. If I'm thinking this is the best advice I've given, then, as opposed to, you know what, I'm going to give you this advice, doesn't really matter if it's wrong or right.
So Eric Bush, he thought he gave the right valuation. It wasn't a matter of good or bad faith. He was incorrect. Is that, I get the impression that doesn't do it for you. But I'm wondering, what is not,
I'm just trying to think, this whole completing the contract or performing the contract honestly.
Yeah, but that has to be an issue. So in Smith and Eric Bush, if we treat this as an exam question, the facts that I gave you, I would say it's hard to pull out a good faith, bad faith argument, because there are no facts that there was conduct like Basil.
Can you clarify for me, because the point is that
Clarify
the
what?
Smith was not the party of the contract,
Right.
right? Because the survey was conducted for the city.
So there's a privity
Yes.
issue.
So I didn't understand how the Smith got this survey at all.
Yeah,
How-
so-
or
that-
the surveyor didn't even have chance to consider that the other
That's what I'm
person
saying.
will.
That's what I'm saying, that here, the case illustrates the point that when we're looking at exclusion clauses, courts are inherently skeptical of them. And will, as I said before the break, will scrutinize them maybe more so than other clauses. So here we have an example of what we might call enhanced scrutiny, leading to a decision that we may find a bit problematic. But the court is saying, well, hold on. You can't have this exclusion clause working here because of, basically, in a term, public policy. Now, we can disagree with the decision, but what I'm trying to convey is, let's understand the decision, and then we can say, well, that was a horrible decision, but articulate why it was a horrible decision in that case. Yeah.
I mean, it's an allied point. It seems that this is a tort claim for the reason.
It overlaps.
Well, is there a contract? I'm not sure if there's a contract between the plaintiff and the defendant. But sorry, when you talk about overlap as a principle,
Contract and tort overlap.
maybe not the basis of the claim by the plaintiff, but the principle, perhaps. Is that what you mean?
Well, Eric Bush is saying I have an exclusion clause.
I hear, because you can typically...
And in negligence, you can't say I exclude liability.
I suppose...
In that way.
I'm just thinking, I don't want to waste too much time, but to the extent where a court says you have a duty to somebody, to act with care and skill, presumably if the exclusion comes to the party's attention, actually you're right, it's probably a contractual claim. Okay, so that probably answers my question. I was asking as a matter of conceptually, is this a contract case or a tort case?
Yeah, so this topic of exclusion introduces us to something we'll look at a bit more later, but I put it sort of at this point because it anticipates tort. Here we have an instance where contract and tort overlap because Eric Bush is going to say, I have a contract, it's with the borough, and you're not part of it. Furthermore, I have an exclusion clause, our issue, that says I can't be sued anyway.
That's vis-a-vis the plaintiff. Because I'm just thinking about, let's say, someone going to your claim would be in the alternative in tort, I guess. Because this is actually a tort claim, but by, I forget the name of the plaintiff here, Smith, because there is no contract between them. So I'm just...
No, but Eric Bush is saying there can't even be a tort claim. I exclude all liability. So for our purposes, so if we, in a contract, what are you excluding liability for? So if you are a law firm, you can't exclude liability for breach of contract because you breached the contract. What is the exclusion about? It's about negligence. Negligently performing your
contractual duty.
Yeah. So you performed it, but you've given bad advice. So you fulfilled the contract, but you've fallen prey to a tort. This is where we have the overlap with an exclusion clause in terms of contract and tort. So where this happens, you have to look at the contract, interpret the contract. If you're the plaintiff, you want to say contract doesn't matter. And there's a reason to exclude all of that, and my claim should succeed. And that's what we have with Smith and Eric Bush.
Do you mind if I just ask one last question? How does one assert a contractual remedy in response to a claim in tort, I guess is really the nub of my question.
You can't really do that, but you can sue in contract and tort.
No,
For example, misrepresentation, and then you have to decide which you can't claim the bill.
I hear. So I guess I'll go and study the case, but I guess just the defense is raised in a contractual context, presumably.
Right, so Eric Bush is saying, nobody can sue me. The council can't sue me because I have an exclusion clause. Smith, you can't sue me. One, you're not part of the contract. Two, I have an exclusion clause anyway. But they still win. So let's skip down to the lead court decision.
Well, if I may just add one thing. Well, there was a contract made between the mortgagee and the surveyor. But the mortgager and the purchaser, they were actually third parties that benefited out of it. So the survey was eventually done for the benefit of them because they could have relied upon it.
Yeah.
That's the argument that it's from contract rather than from tort.
Yeah.
So as someone who draws the benefit out of someone else's contract,
yeah, I didn't go that route because we've done privity and third parties. And I'm not sure if it was clear.
Well, agency and trust and, employment, those kind of things are exclusion. But I'm just thinking about the actual value. It's the mortgager or Smith who was drawing the benefit out of the survey. He wasn't paying for it.
Yeah, and so if you go through the decision, the court uses that kind of language for the benefit of this sort of vulnerable person. 90% of the houses bought or homes bought were by these types of people, so of course they're going to rely on the survey. Lead court, sorry.
Sorry, but in this case, it does not seem fair to me that we have to focus on the recipient. So when we have a contract, let's say that they have a contract here, it doesn't matter if you are low-income earner or high-income earner. You have to trust the other party. So I cannot understand why the court focused here on the low-income earner. Because you said that.
Because they said the low-income earner couldn't afford an independent survey, an independent valuation of the property.
Yeah, but if we think like that, it means that if you're a high-income earner, you have to double-check every opinion.
Yeah. But I guess we can only aspire to be all high-income earners and have that problem.
I wanted to say, even if we will see this from the matter of privity between the parties, that Smith wasn't part of the contract. So Bush could have raised his arguments towards Smith with saying that you are not part of the contract because he would say like the exclusion clause in that context it wouldn't apply like because he didn't sign.
Right, but what I was saying was, so the first argument is you're not a party, privity. Secondly, even if somehow the court says you're a party, I have an exclusion clause. So it's the tiered arguments I was talking about.
But the exclusion clause will apply to the party to the contract, not to Smith. Smith wasn't a party to the beginning.
Yeah,
The way how I understand this.
yeah, but Eric Bush is saying, I exclude liability for anything wrong that I've done with the valuation. Saying that should apply to Smith. Yeah. So the tier is not part of the contract. In the alternative, if the court says somehow you're part of the contract or whatever, I've excluded liability for this. Let go.
So, during construction, cleaners used the wrong tools and they made some damage to the windows, and then the big owners thought that this was covered by the builder's risk insurance policy, but the contract contained the exclusion clause that excluded liability for the cost of making good faulty workmanship. And the issue was whether this clause applied to the so it was a matter of interpretation, whether the subject matter of the action was covered by the exclusion clause, and it was decided that it was not, and that the cost of making good faulty workmanship meant that the redoing of the faulty job was excluded. So the repairs, that the damage was covered under the insurance, and I think it was more about because to deny, to accept the opposite, it would be to deny the whole purpose of insurance policy. So if the builders were not insured against that kind of accidents or jobs, that would put a lot of financial burden on the construction. That's the whole point of having an insurance policy.
Yeah. So here, remember the questions I posed. Is the clause incorporated? Then we go to interpretation. Does the clause apply? LEDCOR actually says the clause doesn't apply here, the exclusion clause. Because as Constantina said, the exclusion clause excluded liability for damage to the windows where the windows had to be repaired. The windows here had to be replaced. And the court drew the distinction between those.
The original.
Sorry?
Yeah, the court made a distinction between the original scope and like said that this one is like out of the original scope of the construction contract.
And what guided the court in this case was, this was a standard form contract. And the court said, well, we usually have this factual matrix, if you recall the Wilberforce decisions from the 70s that we talked about. But when we're looking at standard form contracts, there's less weight given to that. Why would we look at standard form contracts differently from negotiated contracts, Lita?
Because it's not negotiated directly by the party.
Right. So the court is saying we have to be.
And usually in the standard form contract, like I think that there is like bargaining power imbalance. Usually it comes like.
It can. I'd have a tough time with it in this case because both are sophisticated commercial parties. I wouldn't say that there's an imbalance of bargaining power. I think the court is saying we have to be careful. Doubly so when we're looking at an exclusion clause within a standard form contract.
It's contract preferential rule, right? Contract preferential.
Not, contract preferential is where it's ambiguous. There is no ambiguity here, the court is saying. The clause says what it says.
Well, the clause is a little bit ambiguous.
A little
bit only.
But the way that the court is saying is, the the clause only deals with repair, not replacing.
Well, I'm just trying to get the grasp of,
Of lead cord, many people
well,
have.
where we are heading with this, because it seems, we're talking here about third-party liability. Is that what is going on?
No.
In other words, there are two people who are contracted. I'm going back from Smith.
Yeah.
Two people are contracted, but then the third party gets affected. It's
Yeah.
Smith.
Well, here,
And
so if we confine it to lead core,
yeah,
just to be continue with the case.
right,
So the third party here will be the window washers.
right. Who has done the?
They used a steel brush.
Who's done the wrong?
Windows.
Um,
Left marks.
And there was an exclusion clause somewhere.
Say, yeah, by the insurance company saying, we exclude liability for any repairs to the windows that have to be done through faulty workmanship.
I'm just thinking, following the cases going back to Headley Burn and Heller, and then coming down to Caparo,
Yeah.
which is after the 1989, saying that the exclusion clause applies because there was privity of contract.
Right.
Are we saying there's special circumstances where that privity is waived? Like in this case, Smith, that's someone who's poor, for example.
Yeah, so I wouldn't say privity is waived. The idea of an exclusion clause is to exclude liability for tort, negligence. You put that into a contract. What Smith is saying is Eric Bush couldn't rely upon that in that case. Even though Smith wasn't party to the contract, they were, as Bayon said, a beneficiary, I'm using that as a loose term, of the advice provided by Eric Bush. So it's not a waiver of privity. It is in tort. You have no contractual relationship, but you've caused a harm to that person. Are you liable, is the question. And a key part of managing that liability now is the force of an exclusion clause. It says, even if I did something wrong, you can't sue me in tort. So it's not dealing with privity necessarily, it's dealing with the tort liability, which is extra contractual.
And that's the case in the House of Lords decision with Caparo, where you have someone buying shares that were valued by the auditor, and that person couldn't rely that they were.
Actually, no.
No?
No, but we'll get to that on, what day is today? On Wednesday or...
Okay. Or we'll leave it like that.
Yeah.
Okay.
Sorry, lead core. Yeah, so lead core gives us an example of that first stage that I was talking about. Does the clause apply? Talked a bit about Eric Bush, but let me bring in under the heading relative bargaining power. Now, I don't think that's necessarily the right phrase for it, but it's been used in textbooks, so I've used it for that reason. Let's look at the George Mitchell versus Penny Lock Seeds case. I think this is a very interesting case because it's actually a really unique set of facts. And it asks this question. If you have an exclusion clause that's valid in your contract, but you don't adhere to it, you generally negotiate around it, can you all of a sudden give effect to that clause at a later date? And the court, the House of Lords says no. So here, what happened was George Mitchell buys seeds from a good place, Penny Lock Seeds. and the Cs are defective. And the contract says that we'll replace you, we'll refund you the value of the Cs, which is, let's say, £200, which isn't very good for George Mitchell because his loss is over £60,000. So he wants Finney Lock Seeds to reimburse him the $60,000, not the $200,000. Now, I think I've given you the summary of the case, and I gave you the clause in the contract.
Yeah.
In the event of Cs or plants not complying with the express terms of the contract, we will, at our option, replace the defective Cs or plants free of charge to the buyer, or will refund all payments made to us. We hereby exclude liability for any loss or damage arising from the use of any seeds or plants supplied by us, for any consequential loss or damage, etc. But evidence was adduced by George Mitchell that showed that Finney Lock Seeds was in the habit of not giving force to that exclusion clause and instead refunding people what they lost. So George Mitchell says, well, hold on. You carried on your business not giving weight to that clause. You have it. We're not contesting that it's valid. But if you haven't given weight to it, if you haven't enforced it at other times previously, that should invalidate your efforts to enforce it now. And the court agreed. And the thinking of the court was basically, I'm trying to look at it if I gave it to you. Yeah, so the paragraph, the decisive factor is, and then the next sentence, this evidence indicated a clear recognition by the seedsman, Finney, in general, that reliance on the limitation of liability imposed by the relevant condition would not be fair or reasonable. So what the court said was, you, Finney Lock Seeds, recognize that your own exclusion clause was not fair or reasonable, and you operated around it. So now you're coming to us, asking us to give weight to it, but we can't do that, because your own conduct showed that you thought it was not fair or reasonable to enforce it. Does that make sense?
Not at all.
No, what I said,
But
not the
that is a
decision.
completely irrelevant thing outside of the current contract. How you can rely by the rules of evidence about some conduct that happened outside of the subject contract at some previous point in time? How's that relevant? How's that entered into it?
I think what I say is, this wasn't just a random series of events that they brought into evidence. My understanding is that Finney Lock Seeds was in the habit of reimbursing people, and for whatever reason decided with George Mitchell, we're not going to do it with you.
No, they tried, but they couldn't succeed.
I would try to say that if the seed company is a good Samaritan, but doesn't mean that everyone should be Samaritan. The standard for fair and reasonable should as high as for a good Samaritan. So it means that this I think the logic behind the court's decision, but I agree with Dion that this is not a good decision. I mean.
No?
The reasoning is flawed.
Okay.
Because this seed company is very good. I mean, it's a good man. Maybe the boss is a very good man, and that maintain very good practice.
Yeah.
But this doesn't mean that this practice should be the standard, the gold standard for everybody, for as far as fairness and reasonableness is concerned.
Yeah. Okay. So I can understand that. Through high school and university, I worked at a grocery store, and I marveled at how people will bring in food, like half-drunk cartons of milk, and say it went bad. I want a refund. And they continually give refund, they give them a new carton of milk or, you know, new whatever. And my thinking was, well, they were managing the customer. You know, they were trying to show that they wanted to keep the customers coming and so on, even though they probably drank half the milk and left it out, or whatever the case may be. So to your point, I think what you're saying is plausible, that Finney Lock Seeds was just trying to manage all their clients, their customers, and was trying to do right, so to speak, by all of them, and that shouldn't be held against them, is your argument. So, as I said before, the key thing is we can disagree with the decisions, but understand what they're saying first. So the court made a decision. Why did they make this decision? It fits within what we've been discussing. The courts are suspicious of exclusion clauses. They will scrutinize them further than other clauses. And here, the court was in one sense really handed an argument that if you're not going to give weight to your own exclusion clause, why are you coming to us to enforce it? If you make the decision to manage your customers this way, that's your decision. That would be outside of what we do. But on a purely contractual matter, you can't come to us and tell us that a clause you rarely enforce, if ever, should be enforced this time. That's the thinking of the court, good or bad.
In here, the court is taking example of a different contract with a different party.
No,
The salesman
not a different contract. They're saying there's a course of conduct.
practice.
There's a practice by Finney Lock Seeds.
But not this for this contract. For
No,
different.
For other, but as I said, it's not like they found 3 random people. Or that the court was just looking for something. It's hard to express in the abstract, but courts need to be convinced that this is a course of conduct, a practice. So the court was satisfied through the evidence that Finney Lock Seeds was in the habit of not enforcing the clause, the exclusion clause, and instead reimbursing customers.
Yeah, what is interesting is the court is looking beyond the limits of this contract. The court is looking to the salesman's standard of practice. As far as
I don't know. See, let me turn it around. Are they looking outside of the contract, or are they looking at the contract? In that they're saying, you wrote it, you know it's there, but you don't even rely on the clause.
Is there a specific, is there something inside the contract that the salesman will not follow this practice? Or?
No, but it was their practice not to enforce that clause. They instead, as was said earlier, were concerned, I infer, concerned with keeping customers happy. But as I said, the court is saying, if you don't give weight to your own clause, it's hard to come to us and say we should enforce it for you, when your practice has been not to enforce it. Okay.
I think what Ayan is maybe arguing, or I would add to his argument, is that the court had to look at extraneous evidence to determine that was not the practice of the company.
I understand that, but that's why I said, I question whether or not it's extraneous.
It has to be though, I mean, because...
But if you're saying enforce my contract clause, and I can show that you don't enforce it yourself, I say that goes to the contract. I understand you're saying it's extrinsic to matters.
Yes.
But I would say that's a debatable point that the court clearly sided on.
No,
It is relevant.
Yeah, I mean, there's a very paternalistic approach coming through this case and the previous one, Smith. Can I just ask you though, I mean, I accept it, it's law and, you know, so be it. It's the law is an ass sometimes. But I was interested to work out this notion of, and I see their comments about insurance and so on, but it's $200, you know, or £200, whatever the amount was, to replace the seal, and it's 61,000 loss. So there's quite a disparity, and we don't really know, well, I don't know anyway, what the disparity was in some where this company, Finney Seeds, was in fact prepared to compromise. So some of the claims may not have been as significant in some of the other claims, in some of the other kind of compromises that were reached.
Yeah.
So if you're going to go down that road, you probably need to investigate all those other compromises quite carefully.
Yeah, but I would say in the reverse, if you're going to ask a court to enforce a clause that you haven't done, you have a practice of not enforcing, you're taking a risk.
But it's my choice really, isn't it, whether I want to enforce it or
No,
not?
but if it's your choice, but don't come to the court to do something you haven't been.
It seems harsh.
Well, I think it lines up in terms of what the court is saying. We're going to keep people to contracts and so on, we're going to give weight to the contract, but if one party isn't, the party that's relying on it, isn't giving weight to that clause, I think it's almost unfair to ask the court to do so.
But what the court is actually then doing is writing the contract for Finney Seeds, really.
No, I think they're taking instruction from their conduct.
But essentially saying we're writing out this exclusion or limitation clause.
Well,
because of
I
the
wouldn't
conduct.
say writing it out. I think they're taking a strict view, which is consistent with the cases that we've been looking at, that they will scrutinize exclusion clauses because, in the words of Chief Justice Laskin, if you're going to exclude everything, what's the point?
But this is a limitation clause, not an exclusion clause. But yeah,
Right.
I mean, again, I come back to, even if it's bad law, it's law, I suppose.
Yeah, so in terms of what I'm saying is, what do you take from it? If a client is in the habit of not giving weight to a particular clause, that presents a problem for you. Because if you know, you have to think the other side knows. And this case says, good luck. Edward, I saw your hand.
Is it this situation comparable to the like extra promise? For example, like if the landlord like promised me to lower the rent, and I relied on it, okay, and I started to pay lower rent. So he must give me like a reasonable notice when he wants to change the deal. Isn't it like something like that?
Not quite.
Because he like he established like a practice that gave the impression to the customer. Yeah, that's the situation.
Yeah, but in the promissory estoppel scenario, somebody has been put in a very disadvantageous position by relying upon the promise within these certain parameters. Here, we don't necessarily have the same thing. We have the fairness aspect that's similar. We have the court saying it would be unfair in both circumstances, but the parameters of promissory estoppel are very discrete compared to here. Yes.
I'm just wondering, there is two other factors here which I don't understand. One of them that the supply of the wrong seeds was due to the negligence of the Apple and sister company. And finally, the seedsman could insure against the risk of the crop failure caused by supplying the wrong seeds without materially
So
increasing the price.
the insurance was alluded to before, and I didn't pick it up because it comes up much more in tort, but I'll briefly touch on it. Courts, for whatever reason, especially the English courts, seem to factor into their rulings that if somebody can be insured, then it's okay to find them at fault, because insurance will pay for it anyway. That's what they're talking about there. So if you have insurance, what do you care? I'm not endorsing it or anything. I'm just saying this has been the practice, and we see it a lot in the tort cases. So we'll finish with fundamental breach, and I'll pick up with the Hunter and Engineering and Turcon cases tomorrow, but just to touch on fundamental breach. Remember, we had talked about this before, and I talked about it within the confines of the facts of photo production and security core. This is the case where the security guard did the absolute antithesis of securing premises by burning them down. So the court says this must be, sorry, not the court. Photo production says this is a fundamental breach. The House of Lords says, no, it's a matter of construction of the contract, and we're still giving effect to the exclusion clause here. How that's interpreted in Canada seems to be a bit more open. And we see that with the Hunter Engineering case. So do take a look at Hunter, and in particular Turcon, how Turcon has amended things so that we can discuss what happened in mega reporting. So the three cases are Hunter, then Turcon, then mega reporting. And we will pick up, I'll give an overview of duress, unconscionability, mistake, and frustration, and we'll probably deal a bit more with duress and unconscionability because we touched on those. But if you have questions about mistake and frustration, we can take them up as well. And that will conclude contracts tomorrow. Okay? So I'll see you tomorrow.